Good morning, everyone. Can you hear me? Anybody out there?
Yes, sir.
Good. Noran, how are you?
Fine, thank you. How are you, sir?
Not bad at all. Good. Anyway, we are back again. Yet another weekend with another wonderful topic. And we will be able to make justice to it as soon as possible. Several possible matches for Ahmed. Mr. Awad, how are you?
How are you, Professor?
Very well. Judlin. Is Judlin there? How you feel, Judlin? We are in the 6th week. Olia, how are you? Leah was typing, right? Let's check that quickly. Yes, Leah is there. Good. Perfect. All right. Anyway, any question before today's lecture begins? Any issue? Is everybody doing well? Sure. That's fine, Jodlin. Any question, any concern before we start today's lecture? So far, so good. We are progressing at a very steady pace, and I hope we're doing the same with our material and studies. Good. So first, caution, we have some few days to submit our homework. And secondly, I was very impressed. Nora is here. Larry is not here yet. Mr. Awad is here. Okay, Olia is also here. I was very impressed about the discussion and how you guys took it. And that is the best way. That is one of the good things you can ever get in a class. You know, you share your ideas so that others can also do what? Others can learn from you. Sometimes we might not know what we will be doing to our classmates or our course mates. We will be influencing them in a whole way by sharing what you have, by at least giving them some sort of information about your experience. Okay, that alone helps to mold them. Again, you don't know what your lecturer or what your professor will be taking from you. Okay, so it's a win-win situation. That's why I like discussion. I enjoy people trying to put across what they know or what they think. It's not about somebody is wrong or somebody is right. It brings out the best of us. Understand? Right? So at the end of the day, when a question is being posed, we listen to what is coming from one side and the other side, and then we tend to be able to do what? Digest it and know that, hey, okay, this fits the question more than this one. So at the end of the day, we will tend to do what? Have more information and be able to judge our what? Our choice of answers. You know, so it was such a beautiful discussion. For those who have not been to the platform to see what is going on, please log on and then try to share your story over there for us to also hear what's going on. So starting from that point, assuming an employer has just posted something out there in a newspaper, on a radio, whatever it is, about a position. You applied, and it's so unfortunate. You found out that I am the hiring manager, and you were not successful. But all you could receive is, oh, we are unable to move forward with the application. Meanwhile, you do qualify. Do you have a case? Did they do anything against you? Did they discriminate by not just giving you that kind of position? How do we see this? Okay. At the end of the day, we should be able to at least digest this information and then make sure that everything that we know comes out to bear. Okay. And it helps a lot. So those who saw my latest post about Nora and then Larry, you find out that I was trying to do what? Guide the conversation. Although I don't want to just point out that, hey, you are wrong, because that's not a right way of doing what? Of coaching discussion. Let everybody flow. Then at the end of the day, you guide them towards the right way so that they will know, or people will tend to understand better how the whole situation is. So you tend to realize that I brought in what we term as invitation to do what? To treat, or invitation to trade. Okay. So in this particular situation, you tend to find out that they made that kind of publication or advertising to the general world or the global world. Okay. Inviting people to participate in their process. Okay. So invitation to treat in that regards, it's not an offer. Okay. They are inviting you to do what? To participate. Okay. So invitation to either participate, or invitation to treat, or invitation to trade. Okay. So the fact that you did not get a position does not necessarily mean the organization is at fault. Hence, you filing a case at the law court will do what? Will bring you any sort of damages. On that note, we'll start today's lecture. If there is no more questions, if there is no questions and there is no concerns, we'll start today's lecture. If you do remember, we were dealing with contracts last week, and today we are back here dealing with the offer and acceptance. If you remember the elements that really made a contract legal and binding, that was one of the elements, which is one of the 6 elements that make what? Contracts what? Binding. Okay, we had offer and acceptance. We had what? The competence, or the competency of the parties, that is the age. We had the mutual agreement, okay? And then we have proper form, okay? And then that's what I mentioned, right? Consideration, all right? This makes what? The elements of a contract binding, okay? This makes contract binding. So the element of a contract is what I just mentioned, and we are going to treat one of those elements, which is offer and acceptance. Why is it so important? It is very important because it tends to help us in every aspect of our business, being entrepreneurs, being organizational representatives, being employees, being employers, and all sort of things that you get involved in your daily activities or everyday activities. Okay, offer and acceptance is very important. And how do you know that somebody has really made an offer to you? And how does the other party also knows that the offer that he or she made has been accepted? Okay, you have to understand this. Is it because somebody made a promise, it constitutes an offer, or an offer, just like a contract, has to be in written? Is that what it is? At the end of the day, we will find out what exactly constitutes that and how do somebody also accept that. So that is offer and acceptance. When we move forward, you get to understand that there are two favorite words that you hear when treating offer and acceptance. And we will normally say offeror and then offeree. Offeror generally represents the person making the offer, and the offeree is the person who is doing what? Receiving the offer. So generally, that is what we have, and that's what you're going to be hearing in this particular lecture. All right, let's go quickly onto our slide, and then we'll be able to zoom through what we are doing today. Good. So that is offer and acceptance for you. So by the end of this lecture, we are expected to do what? Identify the first step in reaching agreement. Okay, in reaching agreement. Okay, and making sure that you have what? A valid contract. That is what we are expected to know by the end of this section. We're supposed to also be able to explain, okay, and provide examples of the three requirements of what? A valid contract. Sorry, a valid offer. All right. By the end of the day, by the end of this section, we are supposed, or we we anticipate that everybody in this class should be able to do what? Explain and provide the examples, the three requirements for a valid offer. We should also be able to distinguish among what we term as a bid. We should be able to distinguish between what we term as what? Advertising. We should be able to distinguish between public offers. Describe how it relates to offer and acceptance. Okay, by the end of this section, we should be able to do what? We should be able to do that. Again, we should be able to explain and provide examples of two requirements for a valid acceptance. Examples of two requirements for a valid acceptance. And lastly, we should also be able to identify the 5 ways in which an offer may be what? Terminated. An offer may be terminated. The fact that an offer has been made does not mean that it's supposed to be accepted. There are some ways that an offer could be terminated. And the fact that an offer has been made does not mean that, yes, it's always going to be what? Come out clean and it's going to be accepted. All right, let's move forward. So, reaching agreement. Reaching an agreement. I did remember this. That is the 6, if you recall this, I just mentioned this, okay? That is the 6 elements of an enforceable contract. One of the elements is what we're discussing today, which is offer and acceptance. Okay, that is offer and acceptance. A valid contract must have a proposal both offered by the offeror and that's what? Accepted by the offeree. Okay, then we have what? a valid contract. Okay, so a valid contract should always come with what? A proposal. Okay, from either Noran to Jodlin, or from Olia to Rodas, being offeror and offeree, respectively. Okay, depending on what they intend to do. So before that agreement can even come to pass, somebody should bring out something we call offer. And that offer should be accepted by somebody and say that, yes, we can go ahead with this deal. That is offer and acceptance. Requirements for a valid offer. Requirements for a valid offer. How can an offer be seen as valid? Okay, or what constitutes a valid offer? Requirement of a valid offer. All right, for an offer to be valid, one, it must be what? Definite and certain. No uncertainties. Okay, if it is one, you are making a deal about one. Okay, if it is just one phone you are dealing about, it is one phone. It has to be specific. It has to be certain. Okay, you cannot just write a contract in vaguism. Soon as it becomes vague, soon as it's not specific, you are creating room for what? For what we call it, a legal tussle. Okay, because at the end of the day, someone will use that loophole to do what? To go to the law courts. So for an offer to even begin, okay, it has to be definite and certain. All right. Two, it must be communicated properly to the offeree. Okay, it must be communicated properly to the offeree. So you are dealing with me. All right. You intend to do what? You intend to give me $20 every 2 minutes that I talk. Yes, it's good. I like that kind of office. You have to let me know. If it's coming from you, Noran, I will have to hold you to that, you know? So if somebody is offering me $20 per every 2 minutes I talk, that has to be what? To be communicated directly to me. It could be what? It could be on the phone. You can send me a text message. You can call me on the phone. You can send me what? An email, anything. You can send me a letter in the mail just to at least do what? To inform me properly. All right. So in that case, I'm aware that you are giving me or you are offering me some sort of deal. All right. So it has to be communicated properly to the offeree. Made with serious intention that the offeror will be bound by it. Sorry for that. So it has to be serious. You should have serious intentions when dealing with an offer. You cannot just think that you can just say anything because you want to have your way. You can just say anything and then get away with it. No, at the end of the day, it's going to be a problem for you. So if you say it and I end up accepting it, while it tends to be a business, with that kind of intention, is going to be seen at the law court as an offer. And the person accepted it. All right. So these are the three requirements that a valid offer should have. An offer must be definite and certain. As I explained earlier on, there shouldn't be any sort of what? Uncertainties. Okay, to be definite and certain, an offer should be specified. Okay, it should specify all terms and conditions of the proposed contract. As I said, it should be very specific. Okay, be very specific as to what you intend to do, with your partner. Okay, so that is how an offer should come with. Okay, a later disagreement may be avoided if the offer terms are made as specific and clear as possible. All right, good. We are moving forward. An offer must be definite and certain under the UCC. How do we see that? Let's look at it. Under the UCC, an omission of one or more essential terms does not necessarily, okay, make an offer invalid, provided the contract contains sufficient information to prove the parties intended to enter into a contract. So when it comes into business, when it comes into the commercial terrain, there are so many things that protects that deal. So the fact that maybe one or two essential terms does not, okay, that's not, one or two essential terms are not there or is omitted, it does not constitute an invalid offer. That makes it a contract, okay? So we got to be very careful as business representatives, as entrepreneurs, as leaders, as scholars. We should be very careful when dealing with contracts. All right. Don't think that your partner or your vendor, because of one or two things that you think is not in a contract, you can play the vendor, and later on when the vendor goes to court, he or she will not win. Be very careful. It's a big caution to you, because the fact that certain things or certain elements are in that contract, okay, it still could hold under the UCC, under the Uniform Commercial Code, okay? In the Uniform Commercial Code, uncertainty with respect to specific terms does not necessarily, okay, invalidate a contract. Anybody with a question? Good. Let's continue. Offer must be communicated. Yes, as I said earlier on, it must be communicated to the offeree, which could be one person, it could be a public, it could be the whole globe, the whole continent, or the entire world. Okay, this is how an offer should be made. It has to be communicated. All right, it has to be communicated. And like I said, globally, an offer could be made in your country, in your continent, or wherever you find yourself. An offer can be made, but it must be communicated. How do we do that? Personally, through phone, through text messages, through email, through newspapers, through radio. It can be made. It has to be communicated. All right. So that is what we do have. The usual means of communications are oral communication. All right. In person or by telephone, television, or radio. We also have the written communication aspect as well. It could be a letter, fax, email, text, or other written forms. All right. No matter what it is, again, an offer should be communicated for it to be valid. Offer must be communicated. Okay. Businesses often use printed or electronic purchase orders containing terms of an offer. There we go with another interesting one. Purchase orders are considered offers to what? To buy. They are invitation. They are offers to buy. So I remember I put, I think I got a couple of guys. Yes, because people sometimes don't want to really read. And then, you know, that's how you get them. You know, in a purchase order, I throw one question there to find out. The purchase order, the person making the order, who is he? Is he an offeree or an offeror? At the end of the day, I end up getting people messing them up. Okay. Purchase orders are considered offers to buy. Okay. So at the end of the day, the buyer rather becomes what? An offeree, an offeror. And the seller rather becomes what? An offeree. Are we confused here? Okay. So no matter what it is, the little reading you do helps a lot. And it opens the way for you to attack every question with boldness. All right. So that is how it is. You are what? Invited. Okay. You are invited. Purchase orders are considered offers to buy. They are offers to buy. Okay. Offers to buy. At the end of the day, whoever is offering to buy now becomes what? Is somebody on the line?
The offerer.
Thank you. Thank you. At the end of the day, that person becomes the offerer. Okay. And the seller rather becomes an offeree. But in our normal terms, if I am giving the thing to you like the seller, I am the what? The offerer. Okay. And you taking it becomes the offeree. But in purchase order where you are being invited or you are being offered to buy, it means you become the opposite. Thank you. Thank you, Mr. Awad. So communication may be implied by actions of the parties. Communications may be implied by the actions of the parties. Good. An offer must be intended an enforceable obligation. An offer must intend an enforceable obligation. Offers made in an anger under duress. Hey, Noran, if you do not sign this contract, I'm going to blow your head with a gun like this. Can that be an offer? Make me an offer. If you are a billionaire, people just get into your shop, put a gun in your head like this. He said, what do you have? Mercedes Benz. How much do you sell it? He said, $20,000. I'll buy it for $1,000. Make me an offer. Under certain conditions, those offers can seem to be what? Invalid. And it cannot be enforced at the law court. So offers made in anger, I did not just make it out of my will. I was not making that offer voluntarily. Okay. So offers made in anger or jets, all those made under severe emotional strain are obviously not made with the intent of entering into what? A valid enforceable agreement. So I could be sick. Okay. And you think, I think I cited that example last week, and you think you could use that to find a way to steal my properties and whatever I have. Okay. If you do so and it goes to law court, guess what? We'll be able to track. Judges will be able to backtrack. They will be able to question here and there to find out when was that contract made and on what grounds was that contract made. And at a point, they could make that contract invalid. That's why I keep saying, if I'm being invited to go to the hospital to do commission, I'm very careful. Sometimes it's not even necessary, considering the money you make out of it, and then they'll pull you to go to the law court and become what do we call it? And then you go and be a witness. You cannot. Okay, so as a public officer, you make sure whatever you are doing is in line with the rules and regulations. So lack of serious intent must be apparent to a reasonable person. Okay, it must be apparent to a reasonable person. Now let's talk about bid, advertising, and public office. Bid, advertising, and public office. Who is on the line? What do we term as a bid? Who is on the line? Anybody with an idea? What is a bid? Or what constitutes a bid? Some of us, we don't know, so we need to know what it is. Anybody on the line?
Professor, I think bids are also a kind of offer.
And a kind of offer. Okay.
Yes.
How do we normally see bid? Monsoon.
In auctions.
Very good. That's something I'm looking for. It's very popular. Thank you, Mr. Awad. So we tend to see bid mostly in auctions, right? Good. So that is what I was, as a matter of fact, that's what I was looking for the first time. Although it's also a sort of offer. They bring all those things out, and then you know, that guy, what is his name? He will have his bell like this, auctioneer. You know, you have his bell ready. Whenever I say that the amount that it's gonna be whatever he's interested in, he's gonna ring the bell, bring, just like that. But in this modern form, we have it online, okay? And then these applications will be running, and then you click, you put in the money, and whatever it is, at the end of the day, if you win, then you become what? You become the owner of the property after making the payments or the necessary payments and then documentations. So that is bid for you. Advertising, we all know what advertising is, okay? And then public offices, might be me and you, okay? You might be working in a private organization, but soon as you enter into any government entity, you become a public officer, all right? So now, public office is something that is being offered to you and I, okay? So it's at the end of the day, it's an offer being made to the general world or the entire community, country, continent, wherever you find yourself. If something of such is being offered, normally you see your police in your country or your community or wherever you find yourself. Whenever there is a serious issue that they're looking for tips, they're looking for information, they will put some sort of offer online or on the in the newspaper, on the television, or wherever you find yourself, that hey, if you're able to show us this person, or if you find this person somewhere and you are able to give us an intelligence that leads to the arrest of the person, we'll give you maybe $20,000. These are public office, okay? These are public office. So these are the kind of stuff we're gonna be treating moving forward in the next few minutes. The requirement of offer and acceptance is usually standard practice in contracts involving few parties, okay? Complications may arise when there is little or no direct contact between the parties. Complications may arise, especially when we are dealing with advertising, okay? So complications may arise, but when you go into details, you see that how it has been set can sometimes be a basis to do what? To defray that problem, all right? For example, bidding, advertising, and public office. These are what we're going to be dealing. So bids and estimates. Bids and estimates. The fact that you are part of the bid or that auction does not necessarily means you have to win. The fact that I contacted you for an estimate to fix my faulty car, does not mean we have a contract. Does not mean I have given you an offer. So an estimate and a bid does not necessarily guarantees an offer. Okay, that is one thing we have to know. So a call for a bid or material work estimate is a request. It's just a mere request, and everybody can do that. And don't forget, the fact that I came to you for a request of an estimate, I can do the same to about 3, 4, 5 people, just to be able to get the right what? To get the right person with the quality and then the pricing and everything. In the same way we do in the bid, okay? Sometimes you see contractors going into bid for maybe road construction, school construction, whatever it is. At the end of the day, they tend to look for who will be able to do what? Execute that contract effectively and efficiently. What do they check? Depending on the criteria that the bid will have. Do you have the source of funds? Do you have the manpower to be able to carry that kind of contract you are bidding for? Have you even done such a huge project before? So all these will be spelled out in the process of the bid. And at the end of the day, they will be able to choose who that qualifies best. Okay, so it's just a mere request for an offer. Okay, not an offer. So an estimate is a request for an offer, but not an offer. Maybe an invitation to do what? Negotiate. So I'm inviting you. After giving me the estimate, sometimes I look at it and I say, Mr. Watt, is there any way you'll be able to reduce this for me? I think your fees is too much. It's only my transmission, which you should be able to fix in 5 minutes. So if my transmission can be fixed in 5 minutes, why are you charging me so much? He said, oh, no, you are a good friend. So I'm going to make sure that I'm treating you well. That's why I'm giving you that price. I said, okay, no problem. Thank you. Then I'll go to Monsoon. And Monsoon feel like he can do it in less than 5 minutes. Okay, because he has the expertise, because he has the equipment, he has the manpower. So he's going to charge me less than what Mr. Awad is charging me. So if Mr. Awad is charging me $150 and Monsoon is charging me $100, and I feel like he can do the work, he has the expertise, he has the equipment to do it, yes, then I can offer what? Monsoon, that kind of job for him to do it. In that case, we have negotiated, okay? So it's just a mere request, but that request is calling for what? Negotiation. So if we are able to succeed in our negotiation, that's where an offer comes in. Can be accepted or rejected by the person calling for the bid. Yes, so it can be accepted or rejected. All right, it can be accepted or rejected. So such announcement or solicitation is often called what? Request for proposal. So request for proposal is termed as what? It's just like a bid or estimate. Okay, request for proposal is not an offer. Request for proposal is not an offer. Advertising. So this is where the nice things are. Nice things. This is where they are. Who has been doing advertising in his or her office? Anybody here? Can you share with us some of the things you have been putting in the advertising, making sure that you don't fall foul? Anybody out there? I'm gonna call names right now. I know that the business owners and then the organizational representatives. I know you. What do you do?
Putting advertisement for a job post.
Job post. Okay. So before you do that, what goes into it? Can you share with us the background? What do you do?
Well, first I have to be ready with my job advertisement. What I want, what is specifically is there, what kind of job, what criteria, and I check also with the newspaper how much they will charge me, like how
Good.
much they for full page or half page or quarter page, like that.
Good. Thank you so much, Mr. Ahmad. So he shared with us, and it looks like whatever he's been doing in practice conforms with whatever we are saying. So you have to make sure that information being sent is specific and certain. Okay. So whatever he's sending out there, you have to make sure that that is exactly what he intends to send. And checking with the newspaper, the fees as to how much it's going to cost him. If his publication is going to take half of the page or a full page or maybe a quarter of the page of the advertising. So you have to do all these things, and ensure that at the end of the day, his company will not be in trouble. All right. So it is very important when you are putting an ad out there. Guess what? Sometimes, so far as we are humans, we make mistakes. So if we do make mistakes, what happens? This is going to be a very nice question. I'm not going to throw it to Mr. Awad. In advertising, specifically to general merchants, if you do make mistakes in pricing and people pick up the paper and come to you, what happens? Anybody?
I didn't understand the question, Professor. If
Let me
I
repeat.
I am the newspaper and I'm sending my offer to the company. I will for your advertisement. This is half page. It's $100, right? Or it's the other way around.
No, let me repeat the question for you.
Yes,
I
please.
said in this specific question, I'm relating it to general merchants. For example, supermarkets. Okay. You sent an ad out there, an advertising out there, advertising for household appliances and whatever it is. For some reason, you had prices on those appliances or whatever you are intending to sell, offer for sale, okay? And between you and the newspaper publishing that, there was a mistake in the pricing. A customer saw this publication, came in, and then show you the publication or the advertising as to how much you publish that for. What would you do? Would you sell the customer the product at that price? Or what would you do?
I think the advertising company, what's it called, pays the difference.
Okay.
I think the advertising company should be should be punished for their mistakes, not the supermarket owner.
Okay, thank you. So Rodas is responding to the question specifically when the advertising company makes a mistake. So my question is, between you, the owner of the shop, or you, the owner of whatever the products may be that you are advertising, and the newspaper, there is a mistake. The price is not what you intend to sell it. But guess what? Me and Nora, we look at the paper, we saw that it is $20 per iPhone. We jump right there. What would you do, business owner?
Professor, I think that it's just an advertising mistake. So it can be corrected in the next advertise.
You already have
Advertisement.
people behind your door wanting to buy that product.
Well, I have faced something like this here. Simply, the supermarket owner just said, "Sorry, this is wrong. This was a mistake," and he removed the ad immediately. But what happened with the advertisement company, I don't know. But it can be sued. It can be request for compensation.
I like that. That is what I'm looking for. You know, you have already advertised the phone for $20. I saw the publication. I came in. You got to make sure that you sell for that price. I'm not sure if we are following. Okay, you sell for what you advertised. So whatever you advertised, the price you advertised for, that's what you sell for. On a second note, somebody may advertise for a phone, maybe iPhone maybe 5, iPhone 10. And you go in to buy iPhone 10 or iPhone 5 or iPhone 380. And he ended up selling you a different model. If you go to court, what happens? You definitely win. You see, one good thing about business law is it doesn't only stay in the classroom. You have to apply it. That's what I always say. Whatever you learn in this class, make sure you do understand it. It's not about just getting the grades and getting out of the class. But if you understand it, it's going to help you out there. I remember in the past, I took a company to court for a reason that I went to, a lady friend asked me to buy her laptop. And then I saw this ad in the newspaper advertising the computer, brand new computers for sale, laptops, as a matter of fact. I saw it. So this is very nice. Oh, the price looks good. So I went in, I purchased the first one. Then I'm like, wow, these people are so smart. The price is so good. So why don't I buy a second one? So I went in, bought a second one. Who would do that? Maybe Judlin, are you there? So I bought 2 laptops. Guess what? When I came home, I used the laptop. It was working. Just after 2 weeks, I sent the lady's own to her, and then mine had a charging problem. So I went back to the store and I'm like, yo, what's going on here? This computer laptop has a charging problem. And they were like, oh, probably it's coming from the socket that you are using in your home. This is a real testimony. So I'm like, what does that mean? He said, no problem. We will get it fixed for you. And then you come for it. I said, okay, that's fine. I left the laptop with them. They gave me a cheat or a receipt for bringing the laptop back for it to be repaired. Then I left. I came home before the day my appointment to pick up that laptop that is being repaired. The lady called me. Hey, what's going on? This brand new laptop is not charging. And I'm like, oh, what is going on? It looks like there is a problem with a charger. So I told the lady, just look at the back of the laptop. Give me the number. Give me the serial number of the laptop. This has been about 15 years ago. So I went online. I checked the serial number. Guess what? Who is going to be able to continue this for me?
It was fake.
Thank you. Thank you, Rodas. This was a refurbished laptop. So now the whole game gets to go to a very nice corner right now. So the conversation is becoming sweet. I put some pepper in there and some spices. So now that I know that this is fake, this is refurbished, being sold as what? Brand new. I took the newspaper. And fortunately for me, I did not throw the newspaper away. So I went back again, referred the newspapers, and I saw that brand new. So I told the lady to ship her laptop to me. She shipped it to me. Now, my appointment day has reached for me to pick up the one that they are repairing. When I got there, I told them, hey, guys, give me back my money. I'm not buying the laptop again. And they were like, what do you mean? You bought a laptop. You send it home for this number of weeks, blah, blah, blah. You have to take it back home. We will not take it. We will not accept this. I said, listen, either you give me back my money or I'm going to call the cops. He said, oh, you can go call the cops. You can bend the sea. I said, okay, no problem. So I called the cops. They delayed. They did not come on time, and then I left. So when I was leaving, I left the other laptop with them. With this second laptop, no receipt was given to me. But guess what? Look at a smart guy. I recorded them on my phone with all this incident because from the word go, I have seen a deceit seller. You understand? So I recorded them and left the laptop. By force, I left it because they didn't want to take it. So I left it with them while recording them. So as soon as I came back, I filed a lawsuit at the small claims court. We went to court and then the representative showed up and the judge asked me, what is your issue? I told them. So I need my money back. And the representative was like, he came to buy a laptop and he brought it back. He's coming to take his money and blah, blah, blah. And the judge asked, did you make an advertising for this laptop being sold as new or refurbished? So this is a brand new laptop. They are going to fool the judge as well at the law court because when I filed my case, I did not put it in there that they were selling me fake or refurbished laptop. But I said they defrauded me. So at the law court, the judge brought an expert to come and check, and they find out that it was fake. So when they find out that it was fake, guess what? He only brought one laptop, telling the judge that I only brought one laptop. So where is my defense for the second laptop? I said, my lord, I have a recording showing me giving them the second laptop. He said, play it. I played this recording, and the representative could not say anything. And the judge did what? Awarded me the full money for both laptops, in addition to what? That kind of time I have wasted, interest, and my filing case and my filing fees. So it is very important. I'm trying to draw your attention to advertising, that if you find an advertising in newspapers and you want to patronize, even though you have finished whatever you are looking for, you have concluded, make sure whatever paper that took you to that particular place, you keep it for future references. Because you don't know what might come up. If the product turns out to be fake, or it turns out to be not of standard, you can always refer to that newspapers. So it is very important to note that putting advertising in the newspapers does not mean that you are fooling everybody. There are people out there who are very smart. So going back to our word, you have to make sure it is specific, it is certain, so that people or those that are reading for that job post will not be able to do what? Find fault and sue the company. That is advertising for you. So you got to be extra careful dealing with newspaper advertising if you are a representative of your organization or you are an entrepreneur. I'm not sure if somebody have a question about this scenario. Any question? Any contribution? Okay, good. If an advertising or advertisement contains a positive promise, that is a positive statement of what the advertiser expects in return. Somebody on the phone? Oh, go ahead, Chan. You want to say something? Good. So positive statements of what the advertiser expects in return. Okay. So courts may hold that advertising or advertisement as an offer. Okay. So making sure that whatever you put out there does not constitute a specific, does not constitute a breach in offer is very important. Okay. So assuming we are dealing with our case where the job post was made, that the gentleman applied and he was denied, assuming they make a definite over here, okay, in return, it says what? Positive statement of what the advertiser expects in return. Oh, all right, in return, okay. So assuming this job post says that if you hold MBA and you have worked in JNY Limited for 4 days, we will employ you. Then this here in this particular situation becomes an offer. Okay, we will employ you if you have an MBA and you have worked in JZ LLC for 3 days. This is what constitutes an offer. So although it's being published in the newspaper, there will be one specific person who has worked for 3 days with JZ LLC, okay, with an MBA. And that person will consider that as what? As an offer. Is somebody with me? Any confusion? Okay, let's continue. So this is especially true if the word offer is used also in the advertising or advertisement. Okay, this is true when the word offer is also used in the advertising or the advertisement. Okay, the same thing applies. We will, we shall, okay, or offer in the advertising or advertisement. It can constitute an offer. So, advertising errors. Sometimes goods are advertised at an incorrect prices. Yes, we spoke about this. Yes, when issues of such happens and it's a printing error, guess what? It's something between the seller and then the publisher. All right. So the publisher checks his or her notes and finds out that no, the owner gave her $5 and she, in the process of typed what? $50. Sorry, the owner gave them $50 in their process, typed $5. Yes, the processor or the publication owner becomes liable for that error. Okay, so the newspaper becomes liable. So if the error is the merchant's fault, he or she is required to honor any low price that I will walk into the store. That's the first scenario that we cited. Okay, so we find out that this is not is $20. We took the newspaper, we went to the store, we want to buy the item. They say, oh, sorry, I'm sorry, we don't sell this for $20. We have the paper telling us that your store is selling this for $20 between the period of maybe 29th October to 1st of November. Okay, this is just certain and definite, and it's there. You will sell it for me for that amount. If you do not sell it for me at that amount, I have the right to take you to court. All right, so that is it. So if the error is not the merchant's fault, he or she may, as a good business practice, may decide to honor the lower price so that, guess what? The customers might have some sort of interest in their business because they feel like, oh, guess what? It's not even this or that, but let's even give it out. Sometimes in business, you have to lose to gain. Okay, so treating one customer well worth thousands of advertising that you will do. That's what we always say. So public office, advertising that offers a reward, all right, for information being leading to what? Arrest of a criminal. As I said earlier on, it's a public offer. It's a public offer. It's being made to all of us. So anybody who finds that bad guy, all right, can report it to the nearest police station, can report it to the nearest precinct for that person to be what? To be arrested. If that information that you give the police, that tip you give them, aid in arresting that person, then that money will be offered to you. In addition to protection, all right, so that in the future, that person comes out from jail, he doesn't come and beat you up, you know? So that is what it is. So at the end of the day, that's what we term as a public offer. Acceptance of a public offer by anyone indicated by performance of the act. So if you're able to provide them the information that, hey, I saw that bad guy, That bad guy was wearing this. He was driving that. He went through this traffic light here and did that. You gave them that kind of detailed information and it led them to arrest the bad guy. Listen, whenever you get those monies, let me know, because I need to make sure I take my cut, because I'm giving you this deal. So for example, an advertisement in a newspaper offering $200 reward for a dog's return. Somebody's dog is missing. He or she loved that dog so much that he put a 200 booty on that dog. Okay, so that if you find a dog anywhere, you can do what? Bring the dog and come and take $200. Sorry for that. Then you come and take the $200 reward. All right, that is a public offer. And this offer is being made to everybody, anyone who can be able to perform that act. Good. Any questions so far? Good. Requirement for a valid acceptance. Yes, after going through all these offers, how can that offer be considered by the offeree? How would that offer be accepted? All right. What constitutes a valid offer? For an acceptance of an offer to be valid, one, it must be what? Communicated. It must be communicated to the offeror. Oh, yes, I'm going to accept this deal. Thank you. By the end of tomorrow, I will bring you the money. You know, this is what it is. As I'm sitting here, I made such a promise to somebody to buy something that last Friday you should hear from me. As at last Friday, today is Saturday, I've not spoken to him. If I call him tomorrow and said, no, that thing is not available, I cannot do anything, because I gave him a specific day to be able to get back to him. So now that I have not gotten back to him, if he sells that property, I cannot hold him responsible. So it must be communicated to the offeror. All right. So an offer has been made to you. You should be able to respond whether you want it or not. It must be unconditional. If you do this, then you'll be able to get that. No, an offer must be unconditional. Okay, so an offer must be unconditional. All right. So at the end of the day, can somebody say something over here to tell us that he's really following? Because there is a topic coming tomorrow, next week, which is talking about condition. It says
It's clear. It's clear, Professor.
it's clear. Yeah, but I'm not clear here. It says it must be unconditional. And as a valid acceptance must be unconditional. Soon as there is a condition with an acceptance, what happens?
They might change their mind later.
They might change
yes, if the condition differs.
Okay, they might change, something might change, but not their mind. Soon as me, being the offeree, I'm accepting the offer with a condition, what happens? Something happens. Probably I have to throw an example here. Say that again.
Can you make it clear?
Obligation.
Oh, 1 second, Rodas. Award.
Obligation.
Okay, not obligation though. Thank you though. Thank you. Rodas want me to make it clear. If I'm offering my phone for sale for $20, and then Rodas want to buy the phone, but at $18. What happens now? You see the condition. I'm offering my phone for sale. Yes, I want to buy, but at $18. Yes, I want to buy, but I want to pay in installment. Yes, I want to buy, but maybe next week. What happens? Did we all read about counter offer? So, valid acceptance will not have a condition, because soon as conditions comes in, it becomes a counter offer, and that rejects the offer. Are we clear here?
Yes, yes. Now it's clear.
You see, thank you, Rodas. It
Thank
means
you.
somebody is following. You know, so if I say I'm selling the phone for $20 and you say, yes, you want to buy, it is a deal of $20. Soon as you bring in a condition, that offer that I made to sell you that phone has been rejected. So there cannot be condition when we are doing what? Accepting an offer, or we want an offer to be valid. So if you want to have a condition, the original offer will be rejected, and a new one after you have counter offer will be sent to you to be said to agree to the new offer or not. All right, that is I believe we might have to get there later on. I'm not sure if counter offer is still ahead of us. So it is important to determine how an offer is communicated and when such acceptance become legally effective. Okay, thank you. So acceptance communication, method of communication. Okay, the usual forms of communication.
Professor,
Yes,
I have a question.
go ahead,
Can
Mansoor.
you please give us an example of unconditional offer? So how an offer can be unconditional?
An offer can be unconditional by not bringing in any new terms. Okay, we are talking
Like,
about
for
condition.
example, if I want to sell my phone, how can I make the offer unconditional if I want to sell my phone?
The original offer you make should be the original offer. You want to sell me your phone, okay? The fact that I want to sell my phone, I'm done with that offer, okay? If you come in and you want to say, I will buy your phone if you buy, maybe I'm selling shoes. If you buy one of my shoes, you are bringing in a condition. Are you there?
Yes,
So,
Professor. So the price cannot be a condition. So there will always be the price condition on an offer.
no, you
For
don't
example,
get.
if I want to sell my phone, I will tell the buyer that I will sell my phone at $20.
Good.
So is that also a condition? The price?
Price itself is not a condition, but someone can consider. We will talk about consideration next week. You see, soon as consideration, which is a condition is just telling us that you based on certain things to buy the property or to accept the offer. Okay, so if I'm going to say I'm selling my phone, if you want to, and I'm saying it is $20, okay, then you being the offeree says, if you want me to pay it in installment. Are you there?
Yes, Professor.
So installment is not the price, but it's affecting the price. So soon as me being the offeror decide to do what? Bring in with a new term or with a new condition. Okay, it's a new term, it's a new condition. So that condition changes that offer. Because me being the offerer will have to go back and say, okay, if you want to pay in installment, then it's not going to be $20 anymore. But if you are paying it in 2 months, then it's going to be $22. That is why a valid acceptance cannot be with condition. It should be unconditional. Is somebody following?
Yes.
Yes, thank you.
Yeah.
Understood.
Thank you. Let's have more conversations so that it broadens our horizon. That's all we need. We want to make sure that we get out here knowing something. Thank you. So that is acceptance, okay? Acceptance can also be done in so many ways. But don't forget, in business, sometimes it is very specific that an offer may be made through the mail. They expect you to accept through the mail. I'm not sure if any of you are aware of the postal rule. So they might make an offer to you, and somebody will expect you to bring the offer by the end of 30th of what? October 2022. If we do this type of offer, those who don't submit the assignment on time will never get that offer because they will miss it. That is just by the way. So that offer is meant to do what? To go into effect by the end of 30th of October, which is Sunday. If you do not send that offer, okay, through the mail, or if your mail does not have a postmark, by the end of October, which I said end of October, by 30th of October, it means if you your letter gets there on the 1st, or even if it gets there on the 31st, and it still doesn't have 30th, okay, as the postmark, the offer could be considered as a rejected offer because it should be there before 30th. So if your letter gets there 31st and they still have 31st as your postmark because you could have same day delivery, your offer is still not considered as accepted. I hope somebody is following. That is what we term as the postal rule. Okay, so sometimes some offers are being directed specifically as to how to be accepted. Okay, you can accept your offer through the same medium. So when they write the offer, they will say acceptance should be sent via the same medium. So if it was through the mail, it has to go through the mail. If it was through the phone, it has to go through the phone. If it was through the fax, it has to go through the fax. So if you send it, if you receive an offer through fax and you decide to send it through mail, what happens? Breach of offer. It can never hold at the law court. I hope somebody is following. It have to go through the same medium. When a contract or an offer says that acceptance must be sent through the same medium, you have to make sure that the same way you receive the offer, you send through the same way as your acceptance. Any question? Good. So that's what we have there. Exception. If offer specifies a certain form of communication, such as reply by registered mail, reply by return mail, or reply by email, again, has to be done the same way. Otherwise, it's going to constitute an invalid acceptance. And you will think you have a case, you want to take it to court, but Nora judge will make sure that your case will be thrown away. So please, let's review all these things and make sure we are doing what exactly is expected from us. So when acceptance becomes effective, okay, when acceptance becomes effective, general rule is an acceptance because, sorry, when acceptance becomes, when does an acceptance become effective? General rule is an acceptance becomes effective when the parties specify. Okay, general rule is an acceptance becomes effective when the parties specify. So you have, like I said earlier on, you have an offer that came through the mail that they are specifying that specific acceptance should go through the mail. Once you send it through the mail, by the due date or the expected date that you're supposed to sell it, to mail it, now it constitutes a valid offer. If you do not go through the same channel or medium to send that, you do not have a valid acceptance. The offer may explicitly state whether acceptance is effective when by offeree or when received by the offeror. Okay, so I gave this example earlier on. What date? Okay, if it is 30th of October, they will make you aware that if we receive the offer via the mail postmarked before 30th of October, then we consider that as a valid acceptance. If they receive it after that, then you don't have a case. Okay, so that's the mailbox rule over there. If the offer is silent as to the time acceptance, up to the time of acceptance is effective, the mailbox rule states an acceptance sent by the mail or courier is effective when properly deposited in a U.S. mailbox. Okay, so if your letter is postmarked by a specific time or date, then you are good in contract or acceptance. Thank you. Now, let's see what we have. Again, acceptance. When acceptance becomes effective, an acceptance communicated by telephone, by fax, telex is effective when received. Okay, courts are divided on whether an acceptance sent by email or text message is effective when sent or received. See, as technology grows and this world moves into a different age, so many things changes our legal frame. So you have an issue, go to court, and a judge will have a different position on that issue. And another judge will have a different position as well. In this situation that they are telling us here, how would a judge classify an acceptance if it was being accepted, through a test? Is it when it was sent or when it was received? What about email? Is it when it was sent or when it was received? Don't forget, many a times you have emails from Yahoo to Google having some sort of delays, or Google to Yahoo to other networks have some sort of delays. So how does that offer being accepted constitute a valid acceptance if we are using this kind of medium? I'm only a messenger because I'm now going to pronounce on something I have not had the opportunity to pronounce on. So when this case comes before you as a judge, what do you think is the best way to address it? Anybody have an idea? Assuming you have such a case, there is an acceptance that somebody accepted via the phone, by text or email, and it went to court, and probably is supposed to get there by 10 o'clock or 10 a.m. And on the other end, the person received it at 10:02. And he went to court. He said, no, the offer has been abolished. How would you deal with this? I just want to have your opinion on that. Is the question clear?
Was the email sent at 10?
Yes, that's what I want to have your opinion. The email is supposed to be received on a specific day. Go ahead.
The offer email, the first one. He accepted at 10 and it got there at 10:02, at 10:02, right?
Let me repeat myself.
Okay.
The email is expected to be received at 10 a.m. on a specific day, right? But the email was received at 10:02. I just want your opinion on this, basing on Yahoo, Google, and other networks. How would you handle this?
Personally, if the email, the acceptance was to be made by 10, then I would make the response earlier than 10 a.m. so
Good.
that it could reach at that time. So
In
I
that time.
think waiting till the end of the limit time is not a good option.
Thank you, Rodas. Good. Rodas doesn't want to go to court. She want to make sure that she will even meet the time before it becomes it escalates to a litigation. So she will not even wait. She will make sure she will accept it before 10 o'clock. What about some of us? We will have personal issues, and for some reason, we might delay in sending it, and it's already before the law court. What is your opinion as to what is going to happen? Anybody else? It's already before the law court. Well, I don't expect anybody to pronounce on this because, as we could see over there, you see, it says what? Courts are divided on whether an acceptance sent by email or text message is effective when sent or when received. So the judges themselves are confused. But in this scenario, if you have a Google account, and I do have a Google account, then I sent you an email at 10 o'clock, and for some reason you received my email at 10:02, there is something wrong. You understand? So if we are on the same network, then 10 o'clock should reflect over there. The maximum delay should be a minute. Okay? It should reflect. And if it does not reflect, then we have to bring in the network provider, because it should be on the same level. But in a situation where you are on a different network, you can argue that it is what? Because you are on a different network. Okay? So if you're on a different network, I will always urge you to send it as early as possible if you find yourself in situations like this. And guess what? These things happen, but people take it lightly. You might have an interview, you get interviewed, and they will tell you you have to do written exams and send it an hour. Within an hour. If you wait, again, those who always want to send the assignment late, if you wait, okay, till maybe 10 o'clock to send the written part of the interview, and for some reason they receive it at 10:02, an interviewer who is not people person might just say that, oh, he's late, then throw your interview, your written paper somewhere, okay? But somebody who is people person might say, okay, maybe due to circumstances. So we have to try, because these things happens. And when it goes to court, the judges themselves, they find it difficult because they don't know how to go with it. Whether the time you sent it or the time they receive it on the other hand. All right. So that is acceptance for you. It can be very complicated. Silence is not acceptance. Silence is not acceptance. The fact that I'm quiet does not mean you can do everything to me or you can do anything to me. Okay? A person cannot be compelled to speak or right to avoid a binding contract or agreement. So if you read a text, there was this scenario that a new company was established, and this souvenir company decided to send them an offer that, hey, we intend to send you this maybe a branded pen, branded cap, branded backpack, branded jug, and all those things. If we do not hear from you by 29th of October, we will consider this as an acceptance. I do not need to speak. This is an invitation to treat. So I do not need to speak. And guess what? The scenario or the example stated that they did not hear from the company. They printed the materials and they shipped it to the company and demanded what? For their payment. And the other company also did what? Call them to say that, hey, if you do not come and take your items from here, I will sue you at the law court. As a matter of fact, if I was the owner of that company, I would have sued them for keeping the items for them. That is warehousing. Because you do not force people to talk in contract. You cannot force people to accept it. So the fact that you want me to say something and I did not say something does not mean I have accepted your offer. I hope somebody is clear here. So a person is under no obligation to reply to an offer. It's an offer. If you want to accept it, you accept it. If you don't want to accept it, you let it go. So a person is under no obligation to reply to an offer. Silence may indicate assent to an offer only when it's in the contract. We have stated it clearly. We have spoken earlier in the morning that if you call me on my phone, where am I? I'm going to be at a place that the reception is not good. So probably you call my phone, you will not get me. So if you call and you don't get me, please bring me the goods. Silence right there. It means we have accepted the offer or we have agreed on certain dimensions of what we are doing. So we don't need to re-echo it again. At the end of the day, you did not get me, you called, you did not get me, or you send me a test, whatever, you did not get me. You'll be able to ship the items because that is what we said. But apart from that, you cannot tell me that if I did not hear from you, you're going to send me stuff. Meanwhile, I've not accepted it. I hope somebody is following. Silence as example, as acceptance. So we do have these facts. Jim has to board the local train to get to his destination. He got to the station. He gave the money that he has in his hands, which is specifically how much he's supposed to pay to what? To the travel agent in the booth. And she responded with a ticket. All right. Jim or Jimmy does not need to talk because he gave the attendant or the agent the right amount. And the agent need not to ask questions because the right amount is telling him or her where she's going. Unless in a situation that money that you gave could take you to somewhere in addition to wherever you are going, then the attendant need to ask question, because you have provided more than enough. I hope somebody is here. So the teller, without making conversation, will hand him the what? The ticket, because it doesn't require any change. All you have to do is to do what? Give him the ticket, and that's it. So the teller, without making conversation, hands him a pass in exchange for the money he gave. This is where silence can mean what? Accepted. Okay? Or in the other case, as I said earlier on, if you call my phone or text me and you do not get any information, go ahead and bring me whatever I'm supposed to get. Good. The UCC provides that contract for the sale of goods may be made in any manner sufficient to show agreement, including conduct by both parties, which recognizes the existence of such a contract. All right? We said this earlier on. Acceptance must be what? Unconditional. Acceptance must be unconditional. Oh boy, that is what we have here. Soon as you bring in counter offer, Monsoon, soon as you bring in counter offer, it destroys everything. So a counter offer that is conditional or a qualified acceptance of an offer is interpreted as a rejection. Okay, it's a rejection of the original offer. Okay, so as soon as you do that, I'm selling my phone for $20. You said, okay, oh, I'll buy it only if you allow me to pay it in 3 installments. That thing come in, you have done what? You have rejected the offer because you have countered that offer. Unless the offer says, I'm selling this phone for anybody who can make a payment in 3 installments, soon as you bring installment in instead of full payment, then you have rejected that offer. I hope somebody is following. So the general rule of contract, acceptance of an offer must be the same as offer. Okay? Mirror image rule. Mirror image rule. You see yourself. The same thing you see, that's what you buy. Okay? If there are any material, into brackets, important differences between the offer and acceptance, acceptance is regarded as what? A rejection of the offer. Are we clear here? Is somebody here?
Yes, Professor.
All right, thank you. Acceptance must be unconditional. So that's what we said earlier on. And the UCC provides an exception. That's what we said earlier on also. Okay, that exception is, like I said earlier on, let me read. Definite and reasonable expression of acceptance or a written confirmation which is sent within a reasonable time operates as an acceptance, even though it states terms additional to or different from those offered or agreed upon, unless acceptance is expressly made conditional on assent to the additional or different terms. So, if you do not hear from me, okay? If you do not hear from me, consider that as my acceptance. Okay? Consider that as my acceptance. In UCC, it's accepted. Okay, it's accepted. A definite and a reasonable expression of acceptance. That is something you have already, you put in that in place already. Okay, you putting it in place, and guess what? The offeror has already accepted that. Okay, I'm ordering for pens, and it's blue pens. If you go and you are unable to get 1,000 pieces of blue pens, you can bring in 800 and add red, 200 red pens. Somebody there. This is a condition. But once the offeror accepts that in UCC, it's accepted. I hope somebody is there. There is a condition. All right? But exception, because it's in UCC. I hope somebody is here. Okay. Termination of an offer. How can that offer be terminated? How? Offers are terminated by what? One, lapse of time. What do we call lapse of time? Lapse of time. Many offers will come with a specific time. If you do not accept by this time, the offer is considered void. If you don't accept this offer by this time, the offer is considered invalid. But many a times, offers will also be silenced in times of what? Time. So in the case that it is silent, we call something lapse of time. And in the law court, they not usually see that as not less than a year. Okay, so that offer could be terminated if the person wait for that period of time. Okay, and he doesn't show up. Okay, good. So that is lapse of time. Revocation. Before acceptance, I could revocate. I can just tell you, no, I don't want it to offer you this again. Terminate. I have revoked my offer. Okay, before you do accept it, not after you have accepted it. Before you do accept it, I can revoke it. Rejection. Yep, we have spoken about rejection. Soon as you bring in counter offer, yep, you just rejected the offer right there. Death or incapacity. Okay, if I fall sick to the extent that psychologically I cannot think, or I cannot do stuff that makes me seem to be in full force of my being, then I cannot be held to that contract or that offer. Okay, so death, soon as the person dies, that contract or offer is gone. And again, the person got stroke. He cannot talk. He cannot turn his neck to do anything. That contract is gone as well. Unless there was some sort of remedies to that somebody says, okay, if I'm not there, if I'm incapacitated, my son, my wife, my in-law, my so and so should take over that contract. In that capacity, in that situation, yes, the contract will continue. I hope somebody is here. Distraction or illegality. Wherever there is a deal in a cocaine dealing, we cannot have that as what? As a valid offer. So when you are dealing in those kind of stuff and there is an issue, you cannot take it to court because you are using what? A stolen money to buy a stolen good. So at the end of the day, you cannot go to court for redress, okay? And that's what it is. Any question? No question. Termination of an offer. Termination by lapse of time. I've said that already. When offeree fails to accept an offer within the time specified, the opportunity to form a contract ends due to a termination of lapse of time. When no definite time for acceptance is stated in an offer, it terminates after a reasonable time. And what is the reasonable time? What is considered a reasonable time can vary according to the circumstances, usually not more than 1 year. Termination by revocation. An offer that has been neither accepted, don't forget, that's what I said earlier on, accepted nor rejected by offeree may be revoked. Before you accept my offer or you reject it, I can revoke it or withdraw or take it out of the place. That is by the offeror. I am making the offer. So before you accept it, I can revoke it or withdraw it anytime. So the offeror may communicate revocation to the offeree in either spoken or written words. I don't intend to sell my phone anymore, but soon. You are trying to buy this phone for so cheap, you know. So now that you are asking for installment payment that you rejected my earlier offer, then I'm not selling it anymore. All right. So that is how an offer could be terminated also. Again, under the UCC, there is an exception, but according to the UCC, an offer that includes specific time expires automatically when the time is up, unless the offeror chooses to extend the offer. This scenario applies to our email scenario. Okay, this scenario here applies to our email scenario. Unless the person who is receiving the email that is supposed to be there at 10 o'clock says it's okay, probably it might be some sort of technical issues. That's why it got here at 10:02. Okay, other than that, you being the offeree has nothing to do. Okay, so the offeror at any point in time can do what? Can choose to accept the offer, even if it's some few minutes or days or months or weeks late. All right, good. Termination by rejection, as we have said earlier on, a direct unqualified rejection or refusal to accept, terminate an offer. So what I offer you is what I'm saying. If you bring in a different term, you are rejecting it. So that can constitute a termination by that offer that you are, the counter offer you are bringing in. All right. So the offer, once rejected by the offeree, cannot be what? Revived or made a counter offer once rejection is communicated and has been what? Received by the offeror. Okay. Again, but if the offeror acknowledges rejection, yet restates the offer right there, okay, the offeree still has the opportunity to accept or reject. Oh, I can buy this phone in condition that you allow me to pay in 3 installments. No, that's fine. I will allow you to pay in 3 installments. You can make the first one now. You say yes. Okay, deal is done. But soon as that comes in as a counter and the offeror is not prepared for that, that deal is doomed, is gone. All right. Termination by death or incapacity. Mutual agreement cannot occur. Don't forget, if either the offeree or the offeror die or becomes incapacitated or legally incompetent. Legally incompetent. All right. The person is sick and you are forcing the person to sign that kind of deal for you. It cannot happen. It's going to be illegal. An offer is immediately terminated as a result of death or legal capacity of either of the offeror or offeree. Termination by death or incapacity. Although an offer is terminated as a result of death or either of either offeror or offeree, if either the offeree or offeror are bound by an option contract, the surviving party may still be what? Obligated to the contract. I did explain this to you, right? At the end of the day, you have people representing you, right? Very good. That can go through now. All right. An option contract has a provision to keep an offer open for a certain period of time. Okay. In the event of death, the estate of the deceased is responsible to carry out the provisions of the option contract. So you have people who are going to do what? Take care of that business along the line. That is your estate. The people you put in place. Okay. In that case, the offer can continue. Any question? Termination by distraction or illegality. Termination by distraction or illegality. If the subject matter of the contract is destroyed or declared illegal after the offer has been made, but before acceptance, the contract is terminated. Example, Gibson offered to sell Rami her boat for $8,000. While the boat was docked, a storm sank and destroyed the boat. Because the boat was destroyed, Gibson's offer to sell Rami, okay, the boat will be terminated. Is this clear over here, or we have litigants here? Is the last point clear here, or we have litigants? Who is going to force Gibson to offer them to offer the boat for sale?
It's clear, Professor.
It's clear. Okay, thank you. So the center or the item in consideration has been destroyed. So you cannot force me to provide you that item for sale. Unlike in the newspaper, when you see a price of an item, you walk into the store and the item is there. The same thing can apply to the newspaper publication. You went into the store and the item wasn't there. Can you force them to sell it to you? No way. So distraction, okay? Distraction in this case makes the contract or the offer invalid. So that is what we have, and that is the end of today's lecture. I'm not sure if there is something you don't understand. There is any suggestion, any ideas, any comments. I have some few minutes that we can talk about that. Anybody there?
Professor, I have a request.
Okay, Mr. Awad, go ahead.
I just saw that there was a discussion like just before the lecture today, and I believe it's already, the time is already expired for me.
Oh, okay. All right, it's not a big deal. Can you send me $50?
Absolutely.
So you have
Can I pay it
rejected
on
the offer.
installments?
You have rejected the offer, you know.
Can I pay it on installments?
You have rejected the offer, you know. So it doesn't hold anymore. Now I'm going to make you another offer of 200. That's fine. I'll make it available for you. As a matter of fact, go ahead and post. You should be
Okay.
fine.
Okay,
You
thank
should
you.
be fine. All right. I'll
you.
make sure that you're okay. All right. And little by little, we'll get there. I hope these materials, you guys will use it, and then I can't wait to see stars coming out from this particular class. So, any more question? If no more question, hey Noran, are you there? Rodas,
Professor,
go ahead.
yes, I have one question, request. Is
Sure.
it possible to get which answers I got wrong for the homework? Which answer I got wrong?
Definitely. The reason is so simple. You know, I don't even know how to explain it. This university makes it so good for you guys. In some schools, you don't see it at all. You should look for the answer. Okay. Once you got it wrong, you should research. This is why it's an open exam. In the past,
To
go
be
ahead.
honest, I did search for it, and I wasn't able to find it.
All right. So
Yes.
you tell me specifically which one, and I'll be able to tell you because
The last one, this homework, the recent one, the one that's not closed.
okay. So which question? Send me a test. I'll forward it to you. All right. Because
That,
this
that,
is an. Go ahead.
that's the problem. That's the problem. I got 1x, and I did the homework again, thinking I found the wrong answer, but turns out it was not the wrong answer. So I was not able to find which one I got wrong, because all the answers I answered on the first homework seemed right for me.
Okay. That is fine. That is fine. I will send you that. Just send me which one you got wrong, and I will send you that. But
It does
again,
not show. It does not show.
oh, you don't see it.
Yes, that's the problem. I don't see
I
it.
understand you now.
Yes,
I
that's
understand
the
you now.
problem. Yes.
Yeah. You're not supposed to see. You should know your answers. That is what I'm trying to say. You're not supposed to see. In the past, I put in there, and people go in and play with the system and then find the answer right there. But I'm gonna let you know which one you got wrong and the answer to that. Okay.
Okay. There's no need for the answer. Just give me the question, and I will read about
You'll
it.
be able to. Okay.
Yes. Yes. Thank you.
And I think did you see your score, by the way?
Yes. For the
Okay.
homework.
By the end of the day, when the homework is closed completely, right? That is Monday. You will see that.
Okay. Okay.
All right. This is how it has been set. When the homework is closed, when you have taken part of it and it's closed,
Okay.
you will
Okay.
see the answers.
Okay.
Because
That's why it didn't show.
exactly. Because
Okay.
people go in and they play with it, and the answer comes, and then they just put it in. You are not deceiving anyone. Okay. But I've set it in such a way that at the end of when the course is closed completely, you'll be able to see which one you got wrong.
Okay.
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 So
Thank you.
I will check also and then forward it to you if you need it as early as possible so that you'll be able to go through whatever you're supposed to. As a matter of fact, I'm checking right now. Let me see if I can see you right now, and then tell you what it is. But I'm not going to tell you because some have not even done it yet.
Yes. Yes. It's okay.
Okay, let's see. Oh, we still have a lot of people not done yet. Yes. Okay. Ooh. Okay, so that's okay. Your first attempt is that okay? So let me see the second attempt. So the second attempt you have 1. Good.
Oh no, it was the first attempt. The first attempt I got 1x.
Oh, that was the first attempt. Yeah.
Yes, yes. And the second one, I thought I found the wrong answer, but I
Acceptance
yes.
of a public offer by anyone, as indicated by the performance of the act, results in an enforceable contract. An acceptance of a public offer by anyone, as indicated by the performance of the act, results in an enforceable contract. We just said this, and then we gave an example as to somebody's dog is missing. He made an offer to the public. Whoever sees the dog and sends the dog takes the money, right? And when you are in a country or a community, and then the police are looking for a tip or an information to arrest a bad guy, you give them that information, you have performed the act. So at the end of the day, you get the money or you get a booty. So that question is what it is. I'm not going to say what it is. Already you're giving somebody a clue. So it's a true or false question. Okay. It's a true or false question. Are you there, Rodas? Rodas, are you there? Rodas, are you there? Rodas is gone. Okay. All right, that's fine. So, I hope you can hear me. Is somebody there?
Yes, sir. We can
Good.
hear.
So, probably Rodas gave somebody a clue on one question. So that is the question she was having issue with, which is just clear, and the answer is right there. So anybody with any question, any issue? If not, we say bye to each other and we see us next weekend. Mr. Watt, if you don't, if you are not successful, just shoot me a test, okay?
So I have a question,
Okay,
sir.
sir. I will try after that hours.
Sure. Go ahead, Chan.
So when we answer the mid-10, we need to, we need to answer from unit chapter 1 to 7. Am I right?
Midterm,
Because
I'll provide you. I don't want
yes.
to load you too much, but I'll provide you specifically.
Yes.
What modules will come into the midterm?
Yes, sir.
All right.
Yes. Thank you, sir.
Unless you want me to add everything.
Yes, sir.
So you want me to add chapter 1 through 7? If you want me to do that, that will be fine. That makes my work easier.
Yes, sir.
Oh, okay. Mr. Awad, you heard that, right?
No, Professor. Again, please.
You did not hear that.
No.
I'm sorry, Professor. My connection was
That's
interrupted.
fine. That's fine. So did you hear the question, or you want me to go back again?
I didn't hear the whole thing. I think I heard.
Oh, okay. Let
a
me
little
help
bit.
you.
Okay.
Let me help you. It's this is the question. You can hear me, right?
Yes,
Can you hear me?
Yes.
Okay. Acceptance of a public offer by anyone, as indicated by the performance of the act, results in an enforceable contract. Okay. You have given somebody a clue. I'm hoping that person will not go and get this wrong. So an acceptance of a public offer by anyone, as indicated by the performance of the act, results in an enforceable contract. This, we have two examples I shared with you this morning. The first one is about a dog that being the owner made an announcement or advertising in the newspaper for $200 that if you find a dog, you get that money. If you're able to perform the act, the offer was made to the public and you are able to find a dog and you present the dog to the owner, yes, you make the money. If an offer is being made to the public from the police, from the precinct, that hey, there is this guy who broke into this shop and we are looking for him. He's this tall, he's that tall, he's that tall. Yes, you're able to give the police that tip off that I saw this guy, he lives here, he looks like this, he's this tall, he's this color, whatever it is, and you think it's him. If the police followed up and find out that yes, it's him, that tip off, you are going to get the money for that tip off that the police offered. I hope you are there, Rodas.
Yes, I'm here, and I will listen to the recording because my network is really, really bad.
Sure.
Today.
That's fine. That's fine. So that is what we have. And before you go, Chan have suggested that the midsem should include all the chapters from week 1 through the last week that we're going to have the midsem. So that's what we'll have. So guys, if there is no question, if there is no comments, there is no request or suggestion, we will end today's lecture and I'll see you next weekend.
Yes, sir. Thank you, sir.
Thank you.
Thank you, Professor.
Thank you, Professor.
All right. Enjoy, guys.
Thank you,
Professor,
sir.
I want to end, sir. I'm greeting, sir.